Good morning and welcome to today's webinar, Disputing a WCIRB or Insurer Action. I'm Rob Oates, past chairman of the II-ABCAL Emerging Leaders Committee. With us today is Robin McGuire of the California Workers' Compensation Insurance Rating Bureau. The WCIRB has partnered with the II-ABCAL Emerging Leaders Network again this year to offer webinars at no cost to help our agents and brokers increase their understanding of the workers' compensation insurance system in California. For today's webinar, we have muted your phones to eliminate background noises. You can still ask questions throughout the webinar in writing through the toolbar of GoToWebinar. All of your questions will be addressed at the end of the presentation. If you would like a copy of today's slides and presentation, a PDF is available in the handout section of the webinar toolbar. Robin, take it away.
Good morning. My name is Robin McGuire, and I'm the Policyholder Ombudsman. I've been with the WCIRB for 17 years, and I work directly with employers to help them resolve workers' comp-related issues. In this webinar, we'll discuss disputing an issue with the WCIRB, disputing an issue with an insurer, and appealing to the California Department of Insurance if the dispute is not settled by the WCIRB or the insurer. We'll also discuss how to get help and resources that are available. A policyholder has the right to contest the action or inaction of their insurer or the WCIRB. If an employer has tried to resolve a dispute on an informal basis and would like to pursue the issue as a formal dispute, the avenue for doing so is either the insurer's dispute process or the WCIRB's dispute process. If, after following this process, the dispute is not settled, the policyholder may be able to appeal to the insurance commissioner. The WCIRB's dispute process is described in Section 8 of the Experience Rating Plan, Part 1, Section 5 of the Uniform Statistical Reporting Plan, and Section 3 of the Miscellaneous Regulations. The WCIRB and insurer dispute process and appeal process are also described in California Code of Regulations, Title 10, Article 9.7, beginning at Section 2509.40. The result of this process is that the WCIRB's or insurer's action or inaction may be affirmed, modified, or reversed. The insurance commissioner has the authority to review and decide certain types of disputes between insurers, the WCIRB, and policyholders. The commissioner set up a process for policyholder disputes to be initially reviewed by the insurer or the WCIRB in order to give the policyholder the opportunity to settle the dispute with the WCIRB or insurer, and if a settlement cannot be reached, to establish a factual record for appeal. An employer cannot bypass the WCIRB or insurer dispute process and immediately file an appeal with the CDI. After following the insurer or WCIRB dispute process, if the dispute is not settled, the policyholder may be able to appeal to the insurance commissioner. The first step is for the employer to put the dispute in writing and submit it to the WCIRB or insurer, depending upon the nature of the dispute. Let's begin with an overview of the process for disputing an issue with the WCIRB. Here's a roadmap to help you follow along as we discuss each step in the WCIRB's dispute process. The WCIRB's process includes a written inquiry step, a complaint and request for action, and an optional request for reconsideration step prior to filing an appeal with the California Department of Insurance. We'll be discussing several timeframes for submitting and responding to disputes, but don't worry about remembering everything. Timelines and next steps are included in the appropriate regulations and also on the written response from the insurer WCIRB, and the CDI. When the employer submits their dispute in writing to the WCIRB, the first step in the WCIRB's dispute process is called the inquiry. This is unique because the insurer dispute process does not include an inquiry step. It's important that the disputes are submitted in a timely manner. Inquiries must be submitted within the specific time frames. For classification disputes, reporting of experience, or coverage issues, disputes must be received within 12 months after the expiration of the policy. For disputes related to experience modifications, the dispute must be received within 6 months after issuance or 12 months after expiration, whichever is later. If needed, the WCIRB may request more information from the employer. The employer has 60 days to respond to a request for additional information. If the employer doesn't respond within 60 days, the matter is deemed closed. The WCIRB has 90 days from receipt of the inquiry to issue a response. Once the employer has put their dispute in writing, they need to determine which dispute process to address it to, either the WCIRB or the insurer, depending on the nature of the dispute. The WCIRB can only accept inquiries regarding issues within its jurisdiction, such as disputing a classification on a classification inspection report, the calculation of an experience modification, or the ownership of entities for experience rating purposes. Premium or premium audit disputes, employment status issues, and claims handling issues are not within the WCIRB's jurisdiction. The inquiry must be a letter written by the employer and can be submitted to the WCIRB either in hard copy or as an attachment to an email. The inquiry should include the name of the employer, the name of the insurer, the policy period in question, all related policy numbers, and a detailed description of the dispute and why the employer believes the WCIRB's decision, action, or failure to act is incorrect. Inquiries should be submitted to the attention of the WCIRB's Customer Service Department. If the employer is not satisfied with the inquiry response from the WCIRB, they have 60 days to submit a complaint and request for action, which is the next step in the process. The WCIRB has 30 days to respond or acknowledge the complaint. If an acknowledgement is provided to the employer, the WCIRB has 60 days from the date of the acknowledgement to provide a response to the complaint. If not satisfied with the complaint response, the employer can submit either a request for reconsideration to the WCIRB or an appeal to the CDI. The employer has the option to submit a request for reconsideration, but could also bypass this step and file an appeal with the CDI. An appeal can be filed with the CDI following receipt of the complaint and request for action response. Keep in mind that a request for reconsideration should only be filed when there is new information or to correct an ambiguity or misunderstanding within the complaint and request for action. If the employer chooses to submit a request for reconsideration to the WCIRB, it must be submitted within 30 days of the complaint response, and the WCIRB has 30 days to respond. If there is no new information to provide or nothing to correct in the complaint and request for action, the employer may bypass the request for reconsideration step and appeal to the California Department of Insurance. Once again, here's the roadmap of the process. So far, we have covered all of the steps in the WCIRB dispute process: the inquiry, the complaint and request for action, and the request for reconsideration. Now we'll briefly discuss the insurer's dispute process, which is similar to the WCIRB's dispute process. The process for disputing an insurer's decision is found in the Insurance Code and Title 10, Article 9.7, Section 2509. The process is similar to the WCIRB's dispute process. However, the insurer's dispute process doesn't include an inquiry step. For the insurer's dispute process, the first step is for the employer to submit a written complaint and request for action. Complaints submitted to insurers can address issues such as the classifications assigned to employees, application of an experience modification, employee status, premium disputes, and claims handling. The deadlines for filing a complaint with an insurer are the same as when filing a complaint with the WCIRB. If an insurer declines to review the request, if the policyholder is dissatisfied with the decision, or if the insurer fails to grant or reject the request or issue a decision upon review, the policyholder may be able to appeal to the California Department of Insurance. Instructions and contact information for the insurer's dispute process are found in a policyholder notice required to be included in every policy entitled Your Right to Rating and Dividend Information under the paragraph Our Dispute Resolution Process. The notice also includes instructions and contact information for the WCIRB's dispute process, as well as information about filing appeals with the Administrative Hearing Bureau at the CDI. Now let's discuss what to expect when filing an appeal with the California Department of Insurance. Once an employer has exhausted the dispute process with the WCIRB or an insurer, they can file an appeal with the California Department of Insurance. The employer may be represented by an attorney, but it's not required. The employer serves a copy of the appeal on each party named in the appeal. At the same time, the appeal is filed with the insurance commissioner. Even if the WCIRB is not the named party, the employer is instructed to serve a courtesy copy of the appeal by mail on the WCIRB. All service documents should be accompanied by a copy of a proof of service. The administrative law judge will acknowledge receipt of the appeal and provide instructions about what to submit with the appeal. The CDI will decide on policyholder appeals of final decisions by the WCIRB or an insurer regarding classification of employees or experience modifications. The CDI will not address specific claims or claims handling. Those issues are directed to the Workers' Comp Appeals Board. The Commissioner will decide whether an insurer correctly assigned classifications to employees, correctly reported data to the WCIRB, correctly applied the experience modification, and correctly applied a surcharge or other rating plan factors to the policy. The Commissioner will also decide whether the WCIRB correctly assigned classifications on the inspection report and correctly calculated an experience modification. The Commissioner will not decide contract-based disputes, such as whether an employee is exempt from coverage, whether a worker is an employee or an independent contractor, whether an insurer properly adjusted an employee's claim for workers' comp benefits, and whether a premium bill is correctly tabulated, unless it's a classification, experience modification, or surcharge issue. The employer filing the appeal is considered the appellant. The appeal must include the employee's contact information, copies of correspondence between the employer, the WCIRB, and or the insurer, a statement as to why the employer believes the WCIRB or insurer's decision, action, or inaction is wrong, any other relevant documents, and a statement as to whether the employer has previously filed a complaint with the Department of Insurance regarding the same issue. The WCIRB must be served with all appeals filed with the CDI. Even if the appeal is against an insurer, the WCIRB may choose to or be ordered to participate in appeals against the insurer. The WCIRB has an interest in appeals involving the application of the Uniform Statistical Reporting Plan, the Experience Rating Plan, or the miscellaneous regulations for the recording and reporting of data. Once all the information has been submitted, the judge will file an appeal inception notice, which is served on the parties. The WCIRB and/or the insurer have 19 days from the date of service of the inception notice to file their response to the appeal. The parties will participate in a conference call with the judge to discuss the issues on appeal, pre-hearing discovery, and setting a hearing date. Again, the employer may be represented by an attorney, but it's not required. If the insurer or the WCIRB files a summary denial requesting dismissal of the appeal and it's granted by the judge, the appeal process ends. The summary denial can be filed prior to the conference call. The judge may ask the parties to file a pre-hearing brief setting forth their arguments. All parties must file a witness list and exhibit list prior to the hearing. At the hearing, testimony is taken from all parties. The judge may also ask for post-hearing briefs. After the hearing, the judge has 60 days to submit a detailed written decision to the insurance commissioner, who reviews the decision and has 60 days to adopt, modify, or reject the decision. A party may file a request for reconsideration of the commissioner's decision. Let's recap the key points of the dispute process. The first step is for the employer to put their dispute in writing and submit it to the WCIRB or insurer, depending on the nature of the dispute. An employer may dispute the WCIRB's decision, action, or inaction regarding issues such as a classification assignment on a WCIRB inspection report, an experience modification calculation, or the ownership of entities for experience rating purposes. An employer may dispute its insurer's decision, action, or inaction regarding issues such as the classifications assigned to employees, the application of an experience modification, employment status, premium disputes, and claims handling. The ultimate result of the dispute process is that the WCIRB's or insurer's action or inaction may be modified, reversed, or affirmed. There are a number of resources available if you have questions or want to learn more. The Policyholder Ombudsman, that's me, is a resource for California employers. The Policyholder Ombudsman is available to assist employers in obtaining and evaluating rating, policy, and claims information. The Ombudsman may advise employers on any dispute with the WCIRB, the insurer, or on an appeal to the CDI. The Ombudsman does not have the authority to render decisions on behalf of the WCIRB or direct the WCIRB or an insurance company to take a specific action. Contact with the Ombudsman does not constitute initiation of the dispute resolution process with the WCIRB or the insurance company. The primary goal in all disputes is to ensure that the employer understands the rules, regulations, and procedures affecting their dispute, and that both parties understand the position of the other. Here's my contact information. Employers can contact me by phone, fax, or email, or submit a request online using a Request for Assistance link located in the Policyholder Ombudsman section on the WCIRB's website. You can find resources about the dispute process on the WCIRB website, including the Uniform Statistical Reporting Plan and the Experience Rating Plan, which are available under Publications and Filings. The WCIRB's website has a page specifically dedicated to agents and brokers. On the agent broker page of WCIRB.com, you can find out how to access experience modifications and inspection reports using WCIRB Connect. Register for upcoming webinars and view WCIRB e-newsletters such as the Classification and Test Audit Insights. These are free, all free services. Information about filing an appeal with the California Department of Insurance can be found on the CDI's website at www.insurance.ca.gov. We hope you enjoyed today's webinar and that you'll join us for the last webinar in our 2015 Workers' Comp series with IABCAL. To register, go to INSURFEST.org. In addition, the WCIRB will actually be at InsurerFest 2015. Attend our workshop to learn more about the upcoming 2016 changes and get a preview of the 2017 variable split plan. We hope to see you there.
Thank you, Robin. I'd now like to open the webinar for questions you might have. If you haven't already done so, please submit the questions in writing through the toolbar on the right-hand or left-hand side of your screen. Robin, that was a lot of great information. Thank you very much. I know I had a quick question regarding if there's an audit dispute with an insurance carrier regarding classification, what are kind of the first 2 or 3 steps that an agent or broker should take in that situation?
If there is an audit dispute, it will really depend on what the dispute was pertaining to. But if it's an insurer audit and it's really pertaining to specifically the payroll information that's reported there, or maybe a classification assignment that was changed on that audit, that's something that you could direct to the insurer. That should be directed to the insurer as opposed to the WCIRB. I do know that the WCIRB is typically the first stop for agents and brokers and even for employers who get information from our website and they'll contact us. And that's perfectly fine. You're welcome to contact me, or employers are welcome to contact me as a Policyholder Ombudsman, and certainly I can explain to them exactly how and where their dispute should be addressed. So if indeed there is some confusion about where you address the dispute, although I think we've provided some pretty good information today, the employer is certainly welcome to contact me, the Policyholder Ombudsman, and I'll be able to clarify that. And agents and brokers typically contact our customer service department, and they can provide some clarity as well.
Great, thank you.
We have a great question that came in, and it's asking, can an agent or broker use the Policyholder Ombudsman, me, to assist an employer? Typically, again, agents and brokers are directed to call the customer service department, and what an agent or broker can do is advise their client, the employer, to contact me directly. And really the reason for that is because the Policyholder Ombudsman is a resource that's really solely provided to employers. However, the reason for that is we really want the employer to become engaged as well and to understand more about the situation, their dispute, the their workers' comp policy and information. And I know they work very closely with the agent, and the agent typically provides terrific information to them. But sometimes the employer will have a slightly different perspective, slightly different questions, or they may want to get information directly. So that's terrific. And if the employer would then want me to speak with their agent or maybe have a conference call, that's fine after I've made contact with the employer. Any other questions?
Well, I want to thank you, Robin, for spending time with us today and providing us your insight. As Robin did already mention, they will be presenting, the WCIRB will be presenting one final workers' comp webinar on October 14th. To register for the webinar or to download the recorded versions of the webinar, our previous websites, please visit www.iiabcal.org or our YouTube channel for this. In addition, WCIRB experts will be keynote speakers at our upcoming INSURFEST, November 4th through the 6th at the Waterfront Beach Resort in Huntington Beach. For more information and to register, please visit www.insurefest.org. That will conclude our webinar for today. Thank you for participating.